Hello, Happy New Year, and welcome back to another episode of Courts This Week, your go to source for the latest legal updates presented by LiveLaw. I'm your host, Ostika Das, and I'm here to take you through the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. But remember, for a more in depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the ongoing farmers' protest, Member of Parliament Asaduddin Owaisi's plea regarding Mandir Masjid disputes, alleged nepotism in senior designation, the Bar Council of India's appeal to enhance enrollment fee, and much more. So let's dive into the headlines. This week, the Supreme Court criticized the Punjab government for not shifting farmer leader Jagjit Singh Dalewal, who's on a hunger strike, to a hospital as per its earlier directive. A bench of Justices Suryakant and Ujjal Bhuiya emphasized that moving Dalewal does not require him to end his fast, allowing him to continue under medical care. The court expressed dissatisfaction with the state's approach, accusing it of hindering reconciliation and misinterpreting the court's earlier orders. While Punjab's Advocate General claimed efforts were made to convince Dalewal, the bench held the state and media responsible for spreading misinformation. Dalewal, a cancer patient suffering from additional ailments, began his hunger strike on 26 November, demanding a statutory guarantee for minimum support price and other reforms. Reports suggest Dalewal might accept medical aid if the union government intervenes, though the centre and Punjab government differ on this strategy's viability. In a related matter concerning the farmers' protest, where the petitioner has sought the Supreme Court's intervention on broader issues raised in the ongoing agitation, the same bench questioned the union government's reluctance to acknowledge and address the farmers' genuine grievances. Why can the central government not make a statement that their doors are open for their farmers? Justice Kant asked the Solicitor General during the hearing. Ultimately, the court advised the petitioner to engage with the high powered committee it had established for negotiations and directed the union government to obtain instructions on the matter within 10 days. This week, the Bar Council of India filed an application before the Supreme Court seeking to increase the enrollment fee for lawyers from 750 rupees to 25,000. Represented by senior advocate and BCI chairman Manan Kumar Mishra, the council argued that the enrollment fee, last amended in 1993 to 750 rupees, had not been revised for decades despite significant inflation. With state bar councils now restricted to charging only 600 rupees, it was contended that the bar councils and BCI have been left severely financially strained. Accordingly, Mishra proposed amending the Advocates Act 1961 with provisions to periodically adjust fees using the RBI inflation calculator. A bench of Justices P.S. Narasimha and Manoj Mishra, however, questioned the role of the court, asking why the BCI had not resolved the issue directly with the government. When Mishra clarified that they had already approached the Ministry of Law and Justice and sought the court's direction for the government to consider the representation, Justice Narasimha expressed concern about why the regulator needed the court's intervention to prompt the government. Surprised at the nature of this application, the bench has sought the Attorney General's assistance on the issue. Member of Parliament and All India Majlis-e-Ittehadul Muslimin Party chief Asaduddin Owaisi filed a PIL in the Supreme Court to enforce the Places of Worship Act 1991 and regulate how courts handle suits involving religious sites. The petition seeks to prevent hurried survey orders and ensure adherence to the Act, which protects the religious character of sites as of August 15, 1947. This week, a bench led by Chief Justice Sanjeev Khanna agreed to tag the plea with the other petitions challenging the Act's constitutional validity or seeking its enforcement, which are scheduled to be heard on 17 February. Citing communal violence after an ex parte survey order of the Sambhal Mosque, OIC raised concerns about escalating disharmony due to similar lawsuits nationwide. His petition calls for stricter scrutiny before admitting suits, halting proceedings on pending cases, and ensuring survey orders are issued only after due hearings. In a related development, a bench led by Justice Rishikesh Roy directed the registry to place a challenge to the Madhya Pradesh High Court's order for an ASI survey of the Bhodshala Temple Kamal Maula Mosque complex before the Chief Justice, suggesting that it ought to be tagged with a batch of cases related to the Place of Worship Act. This week, the Supreme Court dismissed a PIL challenging a UP court's remarks on love jihad and seeking guidelines to prevent personal or generalized observations in judicial orders. A bench of Justices Rishikesh Roy and SBN Bharti declined the plea, noting the petitioner's lack of involvement in the original case. Justice Roy remarked that the petition was an attempt to sensationalize an issue unrelated to the petitioner. The UP court's contested order had described love jihad as a systematic targeting of Hindu women by Muslim men for conversion under the guise of marriage. These remarks, which have generated much controversy and outrage, were made in the order passed by Ravi Kumar Divakar, the additional district and sessions judge Bareilly, while sentencing a Muslim man to life imprisonment for the offence of rape. The PIL sought to expunge these remarks and prevent similar judicial pronouncements in the future. Ultimately, however, on the petitioner's counsel conceding that their client had no direct connection to the case, the court ended up dismissing the petition as unwarranted interference. The Supreme Court has directed the Uttar Pradesh government to provide medical and inquiry reports on Mukhtar Ansari's death to his son Umar Ansari within 2 weeks. A bench of Justices Rishikesh Roy and S.V.N. Bhati passed the order after senior advocate Kapil Sibal representing Umar argued that the reports, including a magisterial and judicial inquiry report, had not been shared with the petitioner. Mukhtar Ansari's family has alleged that he was poisoned and denied adequate medical care, ultimately resulting in his untimely death in jail last year, despite assurances of protection given by the state to the Supreme Court in response to Umar's writ petition. The petition had sought Mukhtar Ansari's transfer to a jail outside Uttar Pradesh, citing grave concerns about threats to his life. The plea drew attention to a series of alarming incidents, including the deaths of co-accused in related cases and the high-profile killings of Atiq Ahmed and his brother while in police custody. The UP government maintains that Ansari died of cardiac arrest, citing post-mortem results. The Ansari family has, however, contested the validity of the post-mortem results. The ongoing case now focuses on ensuring transparency regarding the circumstances of Mukhtar Ansari's death. This week, the Supreme Court reprimanded Advocate Matthew J. Nedumpara for filing a petition that alleged nepotism in the designation of senior advocates, specifically targeting the Delhi High Court's recent appointment of 70 senior advocates. The petition accused the system of favoring the relatives of judges and called the practice a hijacking of the legal profession by a select few families. The court found these claims scurrilous and baseless and demanded their removal from the petition. Despite initial reluctance from Nedumpara, the court sternly warned that contempt proceedings would follow if the defamatory statements remained. Justices B.R. Gavai and K.V. Vishwanathan made it clear that all petitioners, including signatories, would be held accountable for these unfounded allegations. The court also pointed out that legal arguments, not populist statements, should guide proceedings in the courtroom. Ultimately, the matter was adjourned, allowing the petitioners time to reconsider their position. Notably, during the hearing itself, several co-petitioners and their counsel expressed a desire to withdraw their involvement. This controversy follows the resignation of senior advocate Sudhir Nandaraj Jog from the High Court Selection Committee, claiming the final list of senior advocates was prepared without his consent. The plea challenging the process is now under the Supreme Court scrutiny. This week, the Supreme Court pondered extending its 2018 order mandating color-coded stickers for vehicles identifying their fuel type beyond the National Capital Region. The stickers, introduced as a measure to combat air pollution, distinguish between petrol, CNG, and diesel vehicles with light blue and orange stickers, respectively. The court acknowledged the sticker's importance but emphasized that effective enforcement is necessary to curb vehicular pollution, especially during severe pollution periods as per the Graded Response Action Plan or GRAP. The bench, comprising Justices Abhay Oak and Augustine George Massey, discussed whether to extend the order nationwide using its constitutional powers. Concerns were raised regarding the compatibility of the 2019 High Security Registration Plates HSRP order with earlier provisions under the Central Motor Vehicle Rules. The court proposed a dual approach, applying the 2019 HSRP rules to newer vehicles while maintaining compliance with Rule 50 for older ones. Further, the court mulled over whether establishing regulatory bodies like the Commission for Air Quality Management in NCR could help other major cities combat air pollution effectively. This matter will be further discussed on 15 January 2025. The Supreme Court this week held that criminal trials involving political personalities cannot be routinely transferred outside the state merely due to political influence. This ruling came during the hearing of a petition by Congress MLA Rajendra Bharti, who sought the transfer of a cheating case against him from Gwalior, Madhya Pradesh to another state, citing bias and undue interference. Senior advocate Kapil Sibal, representing Bharti, alleged threats to defense witnesses and biased interactions between a minister and prosecuting officers. The court, however, made it clear that transferring trials due to political connections undermines judicial independence. It also directed that the prosecuting officers allegedly involved in influencing the case be made respondents, adding Abhishek Malhotra and Praveen Dikshit to the case. While the court acknowledged the possibility of state-level interference, it refused to transfer the trial outside Madhya Pradesh and emphasized that any allegations should be examined within the state. Bharti was directed to file an amended cause title and notices were issued to the added respondents. This week, the Supreme Court clarified that the Central Bureau of Investigation does not require the consent of a state government to file an FIR under central law against a central government employee, even if the employee is stationed in that state. The court ruled on a case involving two central employees in Andhra Pradesh accused under the Prevention of Corruption Act 1988. The Andhra Pradesh High Court had previously quashed the FIR, citing the need for consent from the newly formed state of Andhra Pradesh. However, the Supreme Court, in a bench led by Justices C.T. Ravikumar and Rajesh Bindal, overturned this decision. The court emphasized that the general consent granted by the undivided state of Andhra Pradesh continues to apply to both Telangana and Andhra Pradesh. Importantly, the bench also noted that all laws applicable to the erstwhile Andhra Pradesh continue to govern both Telangana and Andhra Pradesh until amended. This week, the Supreme Court intervened in a matter where the High Court had overstepped its writ jurisdiction under Articles 226 and 227, ordering an arbitral tribunal to grant more time for cross-examination. The bench led by Justices P.S. Narasimha and Manoj Mishra set aside the High Court's order, underscoring that interference in arbitral proceedings should only occur if the tribunal's order is patently perverse. The High Court had directed the tribunal to grant additional time for cross-examination, although sufficient time had already been provided. The Supreme Court emphasized that arbitral proceedings are governed by the Arbitration and Conciliation Act 1996, which ensures that both parties have equal and fair opportunities. The court also noted that the tribunal had already allowed adequate time and the respondent's request for more time was excessive. This ruling sends a strong message about limiting judicial interference in arbitral matters and preserving the autonomy of arbitral tribunals. And that's a wrap for this week's Legal News Roundup. But before we bid adieu, the entire Live Law team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audiovisual format, we rely on your support. So here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you subscribe to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments below and hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for our in-depth reports and analysis. Not only this, but the Live Law channel offers memberships for only ₹89 per month. Become part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our Student Pass audience, early access to explainers and legal updates. I'm your host Ostika Das, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to Live Law. Thank you for watching.